If you've been promised a fix for a defective product, had that promise confirmed in writing, and then faced months of silence while your home sits uninhabitable, you're looking at a situation that California law actually takes very seriously. And today, we're breaking down exactly what your options are. This person's story is unfortunately common. $170,000 in Marvin Windows installed in December 2024, defects discovered immediately, and by April 2026, 16 months later, they still can't move in. The windows leak every time it rains. Marvin confirmed in writing that the defects were manufacturing problems, promised replacement, promised to cover installation costs, and then went silent. The question is, what leverage does California law actually give you in a situation like this? Let's start with the foundation of your claim. Your right to think about the Song-Beverly Consumer Warranty Act. That's California Civil Code Section 1790 and following sections. This law is powerful, and it's designed exactly for situations like yours. Here's the key. When a product has a defect covered by warranty, the manufacturer has a legal obligation to either repair it or replace it within a reasonable time. California courts have consistently held that reasonable time doesn't mean infinite time. In one landmark case, Dagger v. Ford Motor Company, courts found that a manufacturer's unreasonable delay in honoring a warranty obligation itself becomes a violation of the Song-Beverly Act. Now, to your first question about timelines. The clock doesn't start ticking from when you first notice the problem. It starts from when you formally notify the manufacturer or dealer of the defect, which you did in January 2025. But here's what matters more. The violation continues to accrue. Every day that passes after Marvin promised replacement and didn't deliver is another day of non-compliance. 5 months to deliver replacement windows after confirming a manufacturing defect? That's almost certainly unreasonable, especially when the original installation was in December 2024. You're looking at well over a year from initial defect to current date. On your second question about willful violations and civil penalties, this is where Song-Beverly gets serious. California Civil Code Section 1794 allows for damages up to twice the actual damages, plus attorney's fees and costs, if the manufacturer's conduct was willful. So, what counts as willful? It doesn't require malice. It means the manufacturer knew or should have known they were breaching an obligation and did it anyway, or simply refused to comply. In your case, Marvin acknowledged the defect, agreed in writing to replace units and cover installation, then didn't order for 2.5 months. They quoted you $10,000 for work that actually cost significantly more, rejected your contractor's detailed itemization, and then went silent for 42 days without responding to follow-ups. A court could look at this pattern, confirm defect plus written promise, plus months of inaction, plus silence on reimbursement, and reasonably conclude that's willful. You have documented evidence of every step. Your third question about the dealer. Under Song-Beverly, both manufacturers and retailers can be held liable. Your authorized dealer was completely useless, as you said, and they're supposed to be the front line of warranty enforcement. California courts have held that dealers can be jointly and severally liable with manufacturers for warranty violations. Whether it's worth pursuing depends partly on their solvency and insurance, which an attorney can investigate. But here's the practical reality. Marvin is the deeper pocket and the one who made the written promises. Your attorney will likely prioritize them, though naming the dealer is often worth doing. Finally, the attorney question. Here's my honest assessment. You're at the threshold. You've sent a demand letter via certified mail with a response deadline coming. If Marvin doesn't respond substantively, or if they reject your claim, you should absolutely consult with a California consumer law attorney. Song-Beverly explicitly makes attorneys' fees and costs recoverable, which means a lawyer can take your case on contingency or with a hybrid arrangement. You're looking at potential actual damages, the difference between what they'll reimburse and what the work actually costs, plus damages for the uninhabitability of your home and the delay. If you're out tens of thousands of dollars on the reimbursement shortfall alone, and you factor in over a year of being unable to occupy your property, the damages could be substantial.